On 15th of February 2024, the SCP clarified the distinction between Khula and dissolution of marriage on the ground of cruelty. The court held that a Muslim woman can seek dissolution of marriage on statutory grounds under the DMMA or seek Khula, which is an independent right. Trial court erred in converting dissolution on grounds of cruelty into Khula without the woman's consent. Khula is a special and exclusive right of a woman which must be explicitly and unequivocally sought by her. Under Section 10.5 of the FCA, waiver of dower is a consequence of Khula, but a woman cannot be forced to forgo her dower unless she voluntarily seeks Khula. Court held that trial and appellate courts misapplied the law by granting Khula when the wife never sought it, leading to wrongful waiver of her dower. Legal distinction between dissolution under DMMA and Khula must be maintained. B. Divorce. Dissolution of marriage. Talaq proof of divorce. Petitioner denied pronouncing talaq, but evidence established that divorce was given in the presence of a jirga and at a police station. Statements of PW4 and PW5 corroborated the wife's claim, and no cross-examination was conducted to rebut these claims. Held trial and appellate courts failed to give a definitive finding on the existence of talaq, despite available evidence. High Court correctly found that talaq had already been pronounced, and granting Khula was unnecessary. C. Dower rights effect of divorce on dower. Right of a Muslim woman to retain dower Khula results in waiver of dower, whereas dissolution of marriage on statutory grounds does not. Since the wife did not seek Khula, and talaq was already pronounced, she remained entitled to her dower, which was half of a portion of the house. Court ruled that denying her dower was unjustified, as dissolution on the ground of cruelty under the DMMA does not affect dower rights. D. Maintenance and dowry articles. Grant and enhancement of maintenance awarded to wife and minor child, with an increase in past maintenance and iddat period maintenance by the appellate court. Trial court also granted rupees 15,000 for dowry articles, which was later enhanced. Held, factual findings of trial and appellate courts regarding maintenance and dowry were justified. No interference warranted by the Supreme Court. E. Legislative history, historical background of the DMMA evolution of Muslim women's rights in divorce cases. Dissolution of Muslim Marriages Act, 1939, was a progressive legislative reform that granted Muslim women greater divorce rights. Before its enactment, Hanafi jurisprudence required the husband's consent for Khula, which was deemed contrary to principles of justice. Statute provides specific grounds for dissolution without requiring the husband's approval, distinguishing it from Khula. Disposition petitions dismissed. Supreme Court refused leave to appeal, upholding the High Court's decision. Held that respondent number 1 was rightfully entitled to dissolution of marriage on the ground of cruelty, and her right to dower was protected. Factual findings regarding maintenance and dowry articles required no interference. Trial and appellate courts erred in converting dissolution into Khula, leading to an incorrect waiver of dower, which was rectified by the High Court and upheld by the Supreme Court. Access the full judgment on www.paclegaldatabase.com.